Hello, and welcome to this episode of The Diary of a Lawyer. And I just want to briefly revisit the affirmative action case that the Supreme Court a few days ago essentially overturned. I want to focus mainly on the dissenting judges, Justice Sotomayor, and in particular Justice Kentanji, who is the only black woman, the first black woman to be on the Supreme Court. But before we get there, I want to just give a brief background and read the majority opinion read by Chief Justice Roberts. So the Supreme Court says that colleges and universities can no longer take race into consideration as a specific basis for granting admission, which is a landmark decision overturning long-standing precedent that has benefited Black and Latino students in higher education. Chief Justice John Roberts wrote the opinion for the conservative majority, saying that Harvard and University of North Carolina admission programs violated the Equal Protection Clause because they failed to offer what he calls quote-unquote measurable objectives to justify the use of race. He said the programs involved racial stereotyping and had no specific endpoint. I'm going to briefly read the quote that he says. He says, the Harvard and UNC admissions, University of North Carolina admissions, programs cannot be reconciled with the guarantees of the Equal Protection Clause, and both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, which involve racial stereotyping and lack meaningful endpoints. He goes on to say that we've never permitted admissions programs to work in that way, and we will not do so today. It's paradoxical, of course, that he is saying race should not be a factor, when in fact, race is a factor in almost every sphere of life in the United States, especially a country that, as one of their foundations, was based on slavery. And it's fitting that slavery a few days ago was, there was a Memorial Slavery Day and a cause for reparation. So, on the one hand, he's saying race shouldn't be a factor, but on the other hand, it is a factor in real life, a point that was picked up by the strong dissents by Justice Sotomayor and Justice Kentanji. But first of all, let me read what Justice Sotomayor wrote. She says, Justice Sotomayor was joined by Eleanor Kagan and Ketanji Brown Jackson, saying that the opinion rolls back decades of precedent and momentous progress, and says that the result of the decision is that a person's skin color may play a role in assessing individualized suspicion, but it cannot play a role in assessing that person's individualized contributions to a diverse learning environment, wrote Sotomayor. She goes on to say that it is indefensible that indefensible reading of the Constitution is not grounded in law and subverts the 14th Amendment's guarantee of equal protection. And in a further demonstration of the controversial nature of the case, justices read their dissents from the bench for the first time since 2019. Sotomayor says that the devastating impact of this decision cannot be overstated while reading a synopsis from her bench. And in ending her dissent, she quoted Dr. Martin Luther King, attempting to end the opinion on an optimistic note. She says, and I quote, as has been the case before in the history of American democracy, the arc of the moral universe will bend towards racial justice despite the court's effort to impede its progress, she said, and pointed out she did not use the customary language, I respectfully dissent. And that can be read by folks in whatever way they wish. Now, in her own dissent, Jackson, who is the only black woman on the bench, as I mentioned, say that the majority have focused or have applied a quote, let them eat cake obliviousness, unquote, in how the ruling announced color blindness for all by what she called legal fiat. And that they're deeming race by deeming race irrelevant in law does not make it so in life, she said. Jackson wrote that the majority had detached itself from this country's actual past and present experiences, as I mentioned, and added that no one benefits from ignorance, which are strong words, but I think some people would argue are fitting. Interestingly, the ruling says that U.S. military service academies can continue to take race into consideration as a factor in admissions, and in a footnote, in the majority opinion, Justice Roberts said that the cases before the court did not address the issue and left open the possibility that there are potentially distinct interests that military academies may present in a future case. However, during oral argument, the Solicitor General Elizabeth Preloga stressed the unique interests of the military and argued that race-based admission programs further the nation's compelling interest of diversity. And Jackson called out the caveat in her dissent. She says, the court has come to rest on the bottom line conclusion that racial diversity in higher education is only worth potentially preserving insofar as it might be needed to prepare Black Americans and other underrepresented minorities for success in the bunker, not the boardroom, and brackets, a particularly awkward place to land in light of the history the majority opts to ignore, Jackson wrote. Now, that's important. Effectively, she's saying that it's okay for underrepresented minorities and Black folks to go to the bunker and in the trenches and give up their lives, where race is not, considered, or at least in terms of whilst using affirmative action, but it's not okay in other professions, including the boardroom. However, it is widely believed that the challenges in the case targeted Harvard and the University of North Carolina, arguing that their programs violate equal protection, but they asked the court to overturn the precedent and insist that higher education explore and further develop race-neutral affirmatives to achieve diversity. But it is believed that, and the Supreme Court stepped in to consider the case before it was heard by the Federal Appeals Court. But it's believed that the legal arguments will continue, and it's not the end of the road, as there is almost a leeway that was left in there that gives room for those who believe in affirmative action to sort of utilize in whilst maintaining the ruling, to be creative in practical application whilst not essentially violating what is now law. And it's a very, again, interesting take again in yet another ruling in the US Supreme Court. But some legal analysts like CNN Chief Analyst Laura Court say the Supreme Court decision will have sweeping changes to the education in the US. She's quoted as saying that the opinion, and she says, make no mistake about it, is going to change the landscape of education, and that's what the majority has asked for. Other observers believe that this will not end the legal fight over college admissions, and they say that in the states that have already banned racial preferences and gone after diversity statements and other softer uses of racial admissions, the decision is going to make it virtually impossible for colleges and universities to take race into account in any specific admissions. However, but in states that continue to permit colleges and universities to take race into account, there will surely be efforts to encourage the sort of kinds of users the majority does not expressly disavow, whether in diversity statements or elsewhere, and litigation challenging those efforts as being inconsistent with the spirit, if not the letter, of today's decision. And that statement is attributed to CNN's Supreme Court analyst Stephen Valdevec, who is also a professor at the University of Texas School of Law. And so that is it in a nutshell, which is a take two of the court's affirmative decision, effectively overturning decades of law, as it did in the case of Roe v. Wade and the gun rights and other issues that have affected and LGBTQ rights as well, which led to the U.S. court, in answer to a question from a reporter, describing the court as not normal, quote unquote. And so, there we shall leave it on this episode of the Diary of a Lawyer, and we shall speak again. Thank you, and thanks for listening. Bye.